Hey, hi, previous. How you doing? Very nice to see you. Very nice to see you guys. Guys, you're most welcome to the conversation. I'm just waiting for Kanso to join in so we get started with the conversation for tonight. You're most welcome. Hey, Doreen, how you doing? How you doing, Doreen? Thanks for coming through for the chat. Hey, Kemi Gisha, how are you? How are you doing, Kemi? Nice to see you, Kemi. Thanks for coming through. Okay, fantastic. So Kanso is here. Allow me to add him as a speaker here. Okay, fantastic. Just a minute. Okay, cool. Kanso, can you hear me? Kanso, I need to confirm if our audio is very okay for today's show. Okay. Looks like Kanso has a network issue, but let me hope we get this sorted. Yes, Kanso, how are you doing? Oh, okay. By just a representation of an emoji. Let me see here. Someone. Okay, thank you, Sharon. You say you're humbled to be here. Fantastic. I don't know if Kanso's network is a bit on and off. Let me check on him again. So, guys, today we're going to be discussing something very interesting as well. If you have been following our series, we're going to be discussing another interesting topic, which, of course, many people could have heard something about it. So, we're going to discuss administrators and executors, how they differ, their roles and obligations. Now, for those of you that have been following our conversations, we've always been talking about issues to do with land. So we've had so many conversations regarding land, from titling to, what do you do if you find out that you've been sold heir, or you've been found yourself as a victim of fraud when it comes to buying land. What's the importance of a will? And so many other things that we have done. So I need to get Kanso on board. I think Kanso is having some issues with his network. Allow me to just try one more time here and see if we can have Kanso coming through. Hey, Kanso, how are you doing? Kanso, can you hear me?
Yes, Fred, I can hear you.
Great. I was worried a bit. I was thinking the network is gonna do something funny, but finally you're here. How have you been, and how has been your week so far?
Thank you. I have been good. I've been well. Uh, I am a bit down. I have some flu that I am battling, but I am hoping that I'll be fine. Otherwise, good to hear from you. I would like to know how you've been doing. I see you are running a campaign, and I wish you well. I don't know if
Yes,
I'm
yes, yes.
a welcome or I am an
Yeah.
influencer. Please let me know wherever I can support or if I should prepare an election petition to challenge the results.
Fantastic. Yes, we're running a campaign. We have an agenda that wants to do a bit of streamlining for the blogging and content creation industry. So that's why I'm getting involved in there, to see that we can have some leadership that can bring us some value. But Kampala has been a bit cold, a bit cloudy today, and lots of land issues, like everywhere on the news and stuff. But last week, after the conversation, there was a lot of thank yous that were coming through. I remember actually some people made the comments live during the show, but then there were so many people that reached out in the DM, and they are so glad. They are so glad that we actually get to share these conversations and create the information that they have been looking for a very long time. So today, without taking too much time, ladies and gentlemen, we're going to be discussing administrators and executors, differences, roles, and obligations. That's what we're going to be looking at. Council, just before we get started, I always find it very, very important to remind our listeners that these conversations are powered by Amity Realtors. And Amity Realtors is the number one real estate agency in Western Uganda. So if you're looking for agricultural land, looking for commercial land, and looking for prime plots within the city, please do reach out to Amity Realtors. They will get you served. They will give you the best service that you've been looking for out there. That said, if you have a question, guys, go ahead and make use of the comment box below on your right hand down. Please make your comment or your question. I'll be able to read it for Council as we go along. So, Council, first things first. The word administrator and the word executor are not actually new to us, because these are words that you have been using time and again to explain a lot of things that we've been learning on these spaces. But tonight, we want to get a crystal clear difference between an administrator and an executor. But before we go into that, let's start from the basics. Who is an administrator in this case?
Thank you, Fred, and to all our listeners. I am happy we are back here today, and as we have always promised you that these chats are always prompted by Amity, but also you, our listeners, it is the topics that you choose that we come up with as a follow-up from our previous discussions. I have received a few concerns of people asking me to clarify on the roles of the administrators and the executors, their limits and their powers, their obligations, what they can do and what they cannot do. Because remember, in our discussion of fraud, you realize that majority of the cases that we have in court are as a result of this management of estates, and the people concerned are the administrators. So a few of our listeners reached out and thought that they needed to know what exactly these administrators do. If they go beyond their limits, what happens? So to have this kick-started, we need to know that an administrator simply means a person appointed by court to administer the estate of the deceased person. And the key distinguishing factor here is with the executor, is that the executor, on the other hand, is just a person appointed in the last will of a deceased person to execute that particular will. So, something that is crystal clear: an administrator is appointed by court, an executor is appointed in the will of a deceased person. That is the clear difference and distinction that I can give for now. Back to you, Fred.
Thank you very much, Council. I think actually that gets us started now. I also know that many people actually could be seeing some of these things play out on a daily within their environments, within their day-to-day lives. But as we talk about these two people, what is one thing that governs them? Who do these people, who empowers them?
Thank you, Fred. Where these people derive their power from, an executor derives their power from a will. An executor is bound by the provisions of a valid will. The moment there is a will appointing an executor, this person is supposed to follow the will to its last detail. And for an administrator, he is governed by the rules of court, but of course, the consensus of all the beneficiaries. So, unless the beneficiaries agree to something, an administrator may not take any action that is contrary to the interests of this estate. Court, of course, is the overall and has powers to cancel their letters of probate in cases of executors and also letters of administration in cases of the administrators. So both the executor and the administrator report to court, but also they owe a very big duty to the beneficiaries of the estate of the deceased person. Back to you.
Great. There's already someone asking a question here, Council, before we go to the next one. Someone is saying, can one person do both roles?
Unfortunately, Fred, it is not possible for one person to do both roles because we cannot have an executor and at the same time have an administrator in respect of the same estate. It's not possible. It's either or.
Okay, I hope Joan got that one. Okay, so Council, I just wanted to clearly look at some of the things that make these people very, very crucial, especially when it comes to properties and management and all that. Why is it very important for someone to actually understand the clear difference between the administrator and the executor? Why is it important? Because someone would be out there saying, why is it important for me to know who does what? Why is it important?
Thank you, Fred. One, it is important that we distinguish between an administrator and executor for one reason being the fact that both derive their powers and obligations in different ways, and there are different procedures that guide each of them. I have given an example. I told you that an executor will only have power under a valid will. Okay? Now, an administrator, in many cases, it could be either or. They are either bound by a will or not bound by a will. We could have an administrator in instances where a deceased person left a will but never appointed an executor. So that administrator as well will be bound by that kind of will. However, an executor, the moment we have an executor, it means that we have a will and that executor has to go by the will. And the other thing is that for an administrator to be appointed, in some cases, they even have to go through the office of the Administrator General, but that doesn't apply to the executor. So that is why we need to have this distinction. And then, of course, the other is to know the benefit of having one over the other. We explained in our last chat about management of estates that where you have an estate and you have appointed an executor, things are easier to manage and go through the process of acquiring a legal heir. Thank you.
Thank you, Council. Let's talk about the properties. Let's talk about these things that maybe the deceased has left behind. I think in your legal language, maybe you call it inventory or something like that. Let's look at how does one get, for example, the administrator. How does one get to confirm that these are actually the properties of the deceased and that is what exactly they are supposed to be managing? Or how do they even also, in case they want to search, how do they search out to make sure that the properties they do take into accommodation or they do take care of is what is known to them.
Thank you, Fred, and to all our listeners. One, when you look at our discussion tonight, what you're talking about is one of the roles of both the administrator and the executor. Once somebody has gotten to that level and they are appointed administrators or executors and they have the mandate from court, their number one role is to do a search and find out all the properties of the deceased person. Here we are not talking only about land, but they are going to go and do a search, find out how much money did this person owe somebody. We call it credits and debits of somebody. Go find out my debts, go find out my credits, even when I am dead. You can make radio announcements, you can ask close associates, but also, you can always ask the lawyers in instances where there has been a will made and an executor is named, and this will was executed by a lawyer or a law firm. Your first point of reference is to that law firm, because the moment somebody makes a will with a lawyer, they have established some trust, and that means that actually the lawyer could be harboring or keeping more secrets of this deceased person. The other avenue you can go to when you're doing this role of discovering the assets, liabilities, and credits of a deceased person is to go through the close relatives of that person. Go to the close relatives, call close associates. The easiest way has always been to call a family meeting of family and friends and all close associates. So that is how that role is usually executed. Once that is done, of course, some things keep coming up. You might find a deceased person who never disclosed all their accounts in the various banks they have, but with time, these keep cropping up. That is why sometimes court will allow an extension of time to have you discover many other facts as they keep coming. When you're doing this role of tracing, you're also going to be required to discover all the children of the deceased, such that we're now able to determine who the actual beneficiaries are and who should be benefiting from the estate of the deceased. Thank you, Fred.
Council, you mentioned a very important aspect. Actually, I had wanted to know when it comes to the administrator, how close should the administrator be to the family of the deceased? How close should this administrator be, and how should their relationship be structured? Because we've had instances where the executor is actually on a different page than the administrator. And in such a situation, who has higher powers in terms of making decisions at the family level, but also legally binding decisions? Who has the higher power, or who has more control? Because we've had those instances where the administrator and the executor are actually not moving in the same direction.
Thank you, Fred. First things first, we are not likely to have an estate where we have an administrator and an executor. That is not going to happen. So we are talking about administrator vis-a-vis beneficiaries, executor vis-a-vis beneficiaries. The obligation of an executor or administrator is to keep or manage the properties of an estate in trust for the beneficiaries. So I am understanding your question to me executor, because the two can never be in the same estate. One, the administrator or stroke executor is simply a custodian trustee. Whatever they do, it should be for the benefit of the beneficiaries. If something being done by the administrator executor is not for the benefit of the beneficiaries, so for example, selling off properties and not accounting, or using such for personal gain, that is going to be challenged in court, and the powers of this administrator or executor will be automatically withdrawn by court.
Council, you have muted. Council, you muted your mic.
Oh, sorry about that, Fred. But I was saying that there is no superiority between an administrator and an executor, and the two cannot arise in the same estate. However, what we compare here is the role of an executor and an administrator as trustees or stroke people entrusted with the property of the estate of the deceased, and specifically for management, but for the benefit of the beneficiaries. So when we look into the other role of the benefit of the executor or stroke administrators is one to do what we call an inventory. An inventory is synonymous to probably what we've talked about of tracing the properties. But here, whoever gets these letters of probate or execution, letters of administration, is given 6 months by the court that grants this probate or administration. And within this time, or any other time, as court may usually extend from time to time, the administrator or executor is bound to exhibit an inventory. This contains a full and true estimate of all the properties in possession and all the credits and also the debits that are owing by any person to which the executor or administrator is entitled to in that character. So once they have done this, then the next step is going to be, which is also the role of an administrator or executor, is to now call for a family meeting and have what we call a distribution of these properties. Of course, when you're talking about distribution of the properties, we are going to consider certain principles that follow. One, we are not going to have this administrator distribute estate of a deceased person without first catering and caring for the debts of this deceased person. You are not going to die and execute an agreement and die, and because you are dead, people forego and forget about their debts. Okay. Number one, if these debts can be approved and we know that yes, this is a genuine debt, the deceased before he died had entered into this contract and this man had been advanced, if the estate is able and capable to pay, that debt should be paid off first. So once that debt is paid, then the next role of the administrator or executor is to go back and consider if there is a will, how do I distribute this property? As the will had earlier on indicated, all as according to the wishes of the deceased person. So once you have done that and you have distributed the properties, you have to make sure that all the beneficiaries or intended beneficiaries are called to this family meeting, and then they are made aware of what is going on. They are given their shares, and you must make sure that they sign for you consent, all taking acknowledgement of receipt of all these properties and benefits that they have received. Once you have done that as an administrator or stroke executor, your next role is now going to be to exhibit what we call an account of the estate to the court, wherein you got the powers of, the letters of administration or letters of probate. Here, you are going to show us the assets which you came across into your hands and the manner in which you have applied or disposed of these assets. Today, the Amended Succession Act talks about payment of school fees for minors until a certain age. So once you are an administrator, that is your role. You have to make sure that any minor within the benefit amongst the beneficiaries is receiving this money, and this is what you're going to account to court. So once you have done that, the best purpose here is to explain to court and the beneficiaries what has transpired during the period of administration of the estate and gain court approval for all acts completed and those that to be completed in the future. You realize that some estates have beneficiaries staying abroad, but because there's an administrator or executor who was appointed, they have to account all these different persons. So usually this role is not a one-off. Timelines are usually extended. Even when you're given a year by court, you could still apply to have the time within which to do this account extended due to various reasons. And these include one, the complexity of the assets that are owned by the estate, and then the extent to which this estate was in debt, because there are debts that you're not going to settle in a day. There are debts that you're going to have to reschedule and pay in periods in installments. Then also, the other aspect that might delay this account is the business interest of the deceased person. You are going to look at a deceased person who probably had shares in 25 companies. All these companies are not going to operate at the same time. They probably have to call general meetings and do what we call a final cleanup and see how to go about with the shares of the deceased persons and dividends, if any. So that's a process that may not take a year or even two. And then the other aspect is that some of the properties of the deceased, which this administrator executor is managing, could be generating income. And some of these assets you are not going to dispose of because you're administering. The beneficiaries may not be interested, or you may not even be able to get a buyer. So you keep managing them, but accounting to the beneficiaries all this income that is being generated. Of course, the other delays are usually or factors, the disputes about ownership of property. You might find that their properties are alleged to belong to the estate, but there's somebody else claiming ownership. Also, there are instances where disputes arise as to value of the property and beneficiaries can't agree on which property to take. The other one is complications that deal with the guardianship of minors, of children of the deceased person. So these are some of the uh, reasons why an account might be delayed or varied or time within which to file the sale extended. Over to you.
Thank you, Council. Ladies and gentlemen, I would love to recognize each and everybody that is listening in. I see so many people here. God leave. I see quite a number of people. Thank you very much for tuning in. Council, there is a very interesting question here, which I want to read to you. There are two actually. Now, one is how and when can a disappointed beneficiary challenge a will? In this process that we're talking about of the administrator, when can someone who is disappointed maybe and they are part of the beneficiaries, when can they challenge a will? At what level?
Thank you, Fred. A beneficiary can always challenge this will at any time this will is read to them. Of course, that is after the death of the testator who made the will. The moment he comes across this will and he has valid reasons, he can always move to court and challenge that will. But speaking of executors and administrators, if somebody has already been granted letters of administration or letters of probate, letters of administration with a will annexed or letters of probate, then if you can have time and find out before these letters are granted, then you can caveat the process and then lodge in your challenge of the will. Court will entertain your application and then the grant will not be given until your reasons for challenging the will are addressed. Secondly, even after this person has obtained the letters of administration with a will annex or letters of probate, you can move court if you discover that the will that was used or that is being relied upon was actually forged. Those of you who have been following our charts, we gave the reasons under which a will can be challenged. So anytime you get to know, you can always have this will challenge.
Okay, fantastic. Thank you, Council. There is another question here coming in from Doreen. Can an executor be a beneficiary of the estate of a deceased person? Because in some cases, such people are regarded as next of kin.
Sorry, Fred, I beg your pardon. I missed the last bit.
Doreen asks a question. Can an executor be a beneficiary of the estate of a deceased person? Because in some cases, such people are regarded as next of kin.
Thank you, Fred. Usually, the law is very clear on executors and them being beneficiaries. Once you have been named as an executor and at the same time as a beneficiary in the same will, you are going to have to choose between the two, because you cannot take two benefits under the same will. So you choose either to be an executor or to be a beneficiary. So if you've been given something in that will, we are going to advise you, and any lawyer will advise you that, look, you can either be an executor or a beneficiary, but not both. Thank you.
Okay, we have another question here coming in from Rogers. Rogers says, what are some of the common reasons for challenging a will?
Thank you, Fred. Commonest reasons for challenging a will: number one, a will that is not witnessed; number two, a will that was made by testator under duress; number three, a will that excludes some of the beneficiaries; number four, a will that excludes some of the properties of the deceased person; and then a will that is basically forged. There are so many other things that could be forged about a will that does not depict the signature or hand of the testator. Those are some of the commonest reasons under which a will could be challenged.
Thank you, Counsel. Someone else is asking a question here that there are so many instances where we have seen administrators colliding with families. In such instances where families are not agreeing on the decisions of the administrator, what should be done?
Usually, when the family, and here when we talk about family, we are talking about beneficiaries. Not any family member is entitled to have a say in the estate of the deceased person. So when we talk about family, I am hoping you are referring to beneficiaries. Number one, ensure that you have a family meeting called to address any challenges that you might be having, but also the last remedy that you have is to apply to court to have the letters of administration or the letters of probate of this administrator stroke executor respectively revoked for reasons that you will give to court, probably of mismanagement, failure to abide by what court gave as guidelines or timelines, but also for misusing the property of the estate for personal gains by this administrator or executor.
Then there is another question here, a very interesting one, Counsel. When someone dies and leaves property and money in the bank, is the administrator also liable to take over the accounts of the deceased in the banks, or the next of kin takes over the accounts of the deceased?
Thank you very much, Fred, for that question. The law is very clear upon death. Upon death, that person has ceased to be. The only person who is going to represent and replace that deceased person is either an executor or an administrator. And according to the decisions that we have of court today, they have tried to give meaning to this. And when you look at the judgment of the Honorable Justice Mbilu in the case of 2018, Anekio versus Twalib, Justice Mbilu talks about an administrator, and he goes on to detail and say that an administrator of a deceased person is his or her legal representative for all purposes, and all the property of the deceased person vests in him or her as such. So once letters of administration have been granted or letters of probate, an administrator or executor is entitled to all rights belonging to the intestate or testate as effectually as if the administration has been granted at the moment after the death of the deceased. So once you have those letters of administration or letters of probate, you are in charge of those accounts. However, and most importantly, your role is simply as a trustee. If somebody, while opening up that bank account, probably made something and said, all that belongs here will be given to my children for their school fees, that is all you have to do. So you are taking over, not to own, but to manage as a trustee in trust for the children or beneficiaries of the estate of the deceased person.
Another question, Council. Is it legally binding for the administrator to take care of the young children in case someone has passed on? Or it's a decision of the family?
Yes, Fred. It is not only the decision of the administrator or executor, but the new amendment of the Succession Act has clearly stipulated it that where we have minors who are still in school, we are having actually a 20% of this estate, whether proceeds or what, devoted to the schooling of these minors. So, actually, if that is not done, then there's a ground for challenging or revocation of this grant of this administrator or executor.
Oh, fantastic. Very interesting questions, Council, coming in. But I wanted you to mention something on the timelines. I know you hinted about it a bit when it comes to timelines, in terms of, the role of the administrator and how things are supposed to get to a point where they're moving. What are the timelines? For example, if someone has passed on and the administrator is supposed to execute his all hard duty to ensure that things continue flowing for the family, what timelines do we look at?
Thank you, Fred. Here, when you talk about timelines, you talk about the timeline someone who has a grant, either of probate or letters of administration that they have. Number one, court will usually give you 6 months to render an inventory. That is, you go discover the dates, the credits, properties, and beneficiaries of the estate, report back to court. And then after that, you'll have still 1 year from the date of grant, within which you'll have to render now an inventory, rather an account of how you have distributed, managed, and probably dealt with the estate of the deceased person. However, most important is that all these timelines can always be extended, but it is usually upon application by the administrator or executor to the court that gave you this grant, and this application must be supported by valid reasons. I gave some of the examples under which the time will be extended. For example, if the estate still has disputes with some properties, or if there are minors and issues of their guardianship has not yet been settled, and so many other reasons. So basically, those are the timelines, but important to note is that these that can always be extended upon application from court by the administrator or executor.
Another question, interesting, coming in from WhatsApp. Someone was listening and they sent it on WhatsApp. They're saying, according to what counsel is saying, it looks like the wife or the husband of the deceased has got no power over the property of the deceased. And if it is true, how much power does the wife of, for example, if it's a man who has passed on, how much power do they have on the property of the man?
Thank you very much, Fred. Now, that question brings in a lot of dimensions, but speaking of administrators and executors, I'll tell you that we have an exception in law where somebody, a spouse, when we talk about spouse, I mean a man or a wife who is legally married to somebody and they pass on, the surviving spouse is exempted from applying for a certificate of no objection from the Office of the Administrator General. This one will go directly to court as long as they can prove that I am a widow or a widower to my deceased spouse. They will move directly to court and they will be granted letters of administration. Now, this applies in instances where either there is no will, naming an executor, or where there is a will but no executor is named. So here a spouse will be given first priority and the Administrator General will not object. Even court will automatically grant unless there is a family member objecting and they have valid reasons for objecting. Some of these valid reasons could be that, look, my lord, your worship, this spouse applying for letters of administration with a will annexed
or without a will annexed has not included some of the properties, has included properties of other people that do not belong to the deceased, or has actually not named some of the beneficiaries or would be beneficiaries of the estate of the deceased. Thank you, Fred.
Uh, Cancer, there's a very, I don't know why for today the questions are actually flowing in a lot, but there is this one. I'm sure you've heard about Hakimi. So someone is trying to bring out some example here. So someone is saying that assuming the deceased, the husband had bought property and registered that property in different names of his kids and different relatives, but it was known that that was his property. Does this mean that there will be no administrator since all these properties are already registered in other people's names?
Thank you, Fred. Hakim brings a very interesting perspective, and I have been discussing with my colleagues in other forum, and I have informed them that actually what Hakim has done as a man is probably to catch up because uh, these people were already 2-0. When you look at most of our societies in Uganda, I would say, I've noticed this with societies in the Western and then rather communities in the Western part where I spend much of my time and practice, but also in the Central. Once a lady is married to a man, this lady and man are probably going to be given a portion of a plantation to cultivate by the father of the husband. However, in the Western, you are given part of farmland, you put your animals, you build your house, but the other bigger farmland is also used and accessed by the other family members. In respect of the plantation, you probably have a portion, and the bigger portion they are telling you it's for your father-in-law or mother-in-law, and they still use it as well. Now, when relationships go sour and these ladies probably want to claim property, these men have always turned and said, look, no, 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 no. That property is not actually mine. The property is for my father. So whatever Kim has done, I don't think it is new. For those who have been in such relationships and such situations, you have seen that this has happened. But speaking of execution and administration of estates, we noted, number one, when we talked about management of estates in our previous charts, that you are not going to manage an estate that is inexistent. If I die, and before I die, I executed proper agreements that are duly witnessed, and I gave away all my property while I was still living, and the people I gave that property are using it, that property does not form part of my estate. It does not. If I write a will and say that the property that I gave to my mother or my sisters, or that is just in the names of my sister, that will is going to be challenged because I am actually now giving or dictating over property that does not belong to me or that did not belong to me even when I was living. Thank you very much.
Council, someone is asking, can a will have a caveat on some properties? Say, for example, if a family land has been left, can a will contain a phrase like, this land should never be sold? And does that bind legally to the administrator?
Precisely to say that is a clause that is wide and ambiguous, but if such a clause is given a timeline, let's say until so and so finishes school, or until so and so reaches age, or unless it is a trust and it is created for eternity for the benefit of future generations. Thank you.
Great. Someone else is saying we have lost lots of money from my father. When he passed on, we weren't able to access his mobile money accounts. Yet I believe that's part of his properties. What should we do?
Okay. For mobile money properties and money is held in banks and online, people have always complained that they don't know the pins, but the simple procedure has always been approach a lawyer. If you have, let's be sure, do you have letters of administration or do you have letters of probate to manage the estate of the deceased? Because that also forms part of the estate of the deceased. Then we shall need to know which company, telecom company, are we talking about? Do we have the number that we're talking about even registered in the names of the deceased? So once you have that and you have letters of administration, then you can write to this company and they should be able to give you access to this account, as long as they can prove that somebody died and there is a legal heir appointed by court or by a will. So that should not be rocket science. Unfortunately, there are timelines within which these monies are applied for. I have just seen an advert, I think it was last week, where banks and telecom companies are actually now remitting all this money that is unclaimed for a certain period of time back to the Bank of Uganda, because that is the law under the Financial Institutions Act. Money that has spent some time on accounts and they're dormant is always remitted back to Bank of Uganda. But still, the hope is not lost. There is always a process that we go through to have all this money recovered. If it's not yet in Bank of Uganda, then the process, I would say, would seem a little easier. Thank you, Fred.
And so Angela says, we have an administrator who has helped us to share the property, but they wanted to sell part of it to get school fees. The family refused and said he should be able to go and chase the NSSF money for our late dad. What is council advising us to do? Should we go ahead and sell part of the property, or we actually go and look for the NSSF for my late father? That is from Angela.
Thank you very much, Angela. But that's a question that really requires an examination of all the other facts. One thing I can assure you of is that according to the Amendment Act of 2022 of the Succession Act, and Section 14, I think it is now 2, which talks about the distribution of property of an intestate upon death. They talk about 20% of the estate not being distributed, but to be held in trust for the education, maintenance, and welfare of all the lineal descendants that qualify as one, a minor child that belong to that intestate, until that child attains the age of 18 years. All until they probably tend to say we are no longer interested in that. Then the other one is any other lineal descendant who is above 18 years of age but below 25 years of age. And if at the time of the death of the intestate, such person was undertaking studies and never married, you have to take care of that child or person or adult, and then also provide for their maintenance and welfare. The third category of persons that are protected or should benefit from this 20% are people who are disabled, and at the time of the death of the intestate person, this person was never married, or were wholly dependent on the estate, rather on the intestate, on the deceased person. So all this 20% is deducted from the estate and cannot be distributed. However, where an estate produces an income by way of maybe periodical payments, the percentage referred to, that is the 20%, can always be derived from this income. So if this estate of yours, my dear friend and listener, has some income that is coming in, we can always have the 20% deducted from that income. Whether or not to go for NSSF or sell off certain properties, that is a discussion that needs a detailed analysis of the general facts that relate to this particular estate and the consensus of all the family members. Thank you.
Thank you, Council. I hope she'll be able to reach out. That's if she can reach out to you. I'm so sure she's listening and watching. So, Council, there is someone who says we need to know if there is need for a lawyer. I think you had actually talked about the legal representative, because this is what I read from the question. But before I even ask that question, would you just give us a bit of, because you see, many people, after they get to know who is running the estate and maybe they have had some agreements, sometimes they get to forget the representation of lawyers and any legal representatives in that process. Would you take us through, if it is really important that in the execution of the roles of the administrator or the executor, there needs to be legal representation at all levels, or it is not necessary, since now the administrator has all the powers and can decide to do what they want?
Thank you, Fred, and our dear listeners. You will notice that in some of these instances, the person that has been appointed by the deceased in a will to be an executor sometimes are not even learned. Sometimes they're not knowledgeable in the law. Same applies to the family, the administrator. They, in most cases, actually have no knowledge about the law, the procedure. So at the end of the day, like my good friend Philip will always say, you will always need a lawyer before the fact. So the moment you discuss all these, always have a lawyer to legally advise on the procedures. When I talk about them here, they might sound quite easy and simple, but also might sound quite complicated. So do not hesitate to reach out to any lawyer. For example, if the deceased left a will with a law firm, that's the first contact, because you have to know that that deceased person trusted this lawyer or the law firm with the management of their estate. So for you, consulting them is a necessity and you cannot avoid it. Thank you.
Okay, fantastic. I don't know if there is someone within the audience that wanted to say something or wanted to supplement on this conversation. I can see Council Munavi, I can see Godlieve, I see Dafla. We have quite a number of people tonight listening in. So, guys, if you want to supplement something before I call on Council to do his last remarks. But before we go to that, I would actually love to ask you, all of you, that you do follow Council Alan, you do follow Amity Realtors. These guys have helped us actually learn a lot. I get a lot of feedback coming in from people. It's so surprising that a lot of people are struggling in silence, Council. A lot of people are struggling silently, and maybe somehow, somewhere, some of these spaces are now helping people to open up and also to know if they are doing the right thing. So if you want to supplement something, please go ahead, request for the mic. I'll grant you the mic. But as of now, let me ask Council to comment about something here. Someone has asked. Just a minute. Let me pull it up. Okay. Okay, so Council, someone says that there are instances where family members pass on after they have shared into property. Who takes over the property of someone who has passed on before they have their own family as husband or wife?
Usually, in instances where there are people entitled to benefit and they are dead, you are saying if they are not having their families, that person is not definitely going to have a share in the estate, but probably that share will be distributed amongst all the other beneficiaries equally. That's if I get it right. But also, remember, this person can also write a will and say, the share I have, all I am entitled to in my father's estate will go to my sister. So if there's such a will, although rarely, but if it is there, that can also be respected. But in absence of that will, if somebody dies and is entitled to benefit, but they are not leaving any lineal descendants, then we can always consider their dependent relatives or next closest relatives in bloodline. Thank you.
Jude says, Council has ever talked about soldiers and not being able to make wills. Where does that leave the properties of a soldier, and what is the process in case someone dies without a will attached to their properties? That is coming in from Jude.
Thank you, Jude. In instances where a person dies without a will, for example, soldiers, the procedure is the same. We shall have that person apply at the office of the Administrator General, and then we have letters of administration without a will annex granted to whoever the family members will have chosen. We had a whole discussion about that procedure last time, but rest assured that the remaining family members can always sit from a family meeting and appoint one or two people to be granted letters of administration. Thank you.
The next I have in my inbox is saying, Council, please tell us how we can get in touch with you and where we can find you. I think this is one of our new listeners who wants to know how can they get in touch with you and where can they find you.
It's okay. Please follow me. I'll always be ready to respond to all your concerns on Twitter. And in Imbara, our offices are located just above Foodmart. If you've heard of Foodmart restaurant, just next to Stanbic Bank. But for ease of reference, please follow me and feel free to inbox me or ask any question on the chat or on Twitter and tag me. We'll always have a response. You can also tag Amity Realtors. We'll always have your concerns responded to. Thank you very much.
At this juncture, I would love to thank our sponsors who always actually. Now, let me tell you, ladies and gentlemen, this conversation has been on for some good time. I am so happy. I wish Council Godlive kindly request for the mic. I have a question for you. Kindly request for the mic, Council Godlive. Yes, so Amity Realtors has always empowered our conversations, and one thing you guys can do for me is please go follow them and also let them be empowered by your references, and also do support the business because they do take time to sponsor these conversations. And we've done over 20 episodes with different people. We've done over 7 episodes with Council Alan. Something unique that I have actually come to believe, Council, maybe just to let you know, the conversations we've had make sense now when I go back to the first conversation we had and I start to follow through to the latest one. And this also, leads me to my next point. If you really want to catch up with some of the conversations that we've been having, the other episodes, please do check out Amity Realtors YouTube channel. Just subscribe and turn on the notification. You never know when this conversation will actually save you, or your friend, or someone you know, a family member, because the knowledge that you learn can actually help you guide you on the next steps that you're going to be taking. I have a comment here coming in from wow, I've lost the comment. Where is it? Okay, it is here. Adam says, thank you, my friend Herbert Tushabe. I am Adam Rooms, Daily Expert Realtors. Glad to be here. Okay, this is to thank Herbert, I think, and Amity for empowering these conversations. Yes, Council Philip, allow me to respond to your I think maybe Council Philip's network is a bit slightly weak because I had put him as a speaker, but it looks like he's back to the listeners section. Council Philip, if you could respond, I have sent you a request to speak. But apart from that, as we wait for Council Philip, Council Alan, I seem to be having some questions coming through, but many of them are just comments that you've already talked about. It looks like a lot of people are actually interested in this topic, but I would love you to make your remarks. What are the key takeaways from today's episode? especially when we're talking about administrators and executors. Maybe before you go on, Council, there is a lot of conflict and a lot of lives lost at this level. And because of that, I think this is because, according to the questions, this is a session where I have had the highest number of questions coming in from our listeners, and that already speaks something. But from personal experience, I also know that a lot of people are actually getting antagonized at this level when someone has passed on. At the sharing of property and everything. Council Phil,
Yes, Sugarman, thank you.
yes, please go ahead
I
with
hope
your
I
comments.
can be
Maybe you could
heard.
introduce yourself for those. You could introduce yourself for those that could be listening to you for the first time.
Oh, thank you very much. I'm Council Philip Monavi. I work with Diadem Advocates in Kampala. I've always been a participant on the platform, though for the last 2 weeks I've been away in South Africa. But I thank my colleague for doing justice to the topic today. I just wanted to commend him for the good work.
We figured you are missing. We figured you are missing in action. I was almost asking Council Allen, but then I said, we always talk about the hustle going on and the good hustle going on. So, but welcome back, and very soon we'll visit you maybe for some goodies from South Africa. Council, go ahead.
Thank you. I had wanted to comment on the Hakimi mode of Ashraf Hakimi. It's a question I had, but my network was on and off. But I think this is something that is embedded in our customs. We have already seen, when you look at family settings, customary family settings, you go to your father gives you a plot of land, you marry from there, you have children from there. When time comes for divorce or separation, you leave everything there. But like we talked in the first conversation, it also gives us knowledge of what we call estate planning and succession planning. How do you manage your property while you're still alive in order not to cause confusion when you're away? The administrators, executors, and all such people may still have problems with beneficiaries, but if you had done estate planning properly when you're alive, like how you share your property with your wife, we had a topic on ownership of property. That helps you to manage your estate while you are alive for the benefit of the times ahead. Thank you.
Thank you very much. Thank you, Council Philip. I had wanted to hear a word from Council Godlive. I don't know if she's able to send us a request, or maybe she's on the move. Okay, for now, I will just remind you guys, if you are out there looking for commercial land, looking for agricultural land, looking for farmlands, many times we come listen to these spaces, but I want you guys to also take advantage and opportunity of Amity Realtors to be your real estate agency in Western Uganda. These guys are doing an amazing job. From the time we started doing these spaces, there's something that maybe Amity is teaching us. Many brands fear to have such programs because they fear the feedback. Many people will come and comment, hey, you stole our money, you stole this and that. I have never got a negative comment about the services offered by Amity. I think, to me, that is a very, very good reputation. Given the fact that we've even having episodes with Council Allen, maybe Council Allen can tell us if there's anyone that has complained to him that we've associated ourselves to Amity and Amity is not that clean. But for all the episodes I've done, I have not had a single person come to give feedback that is negative. So I want to say cheers to Amity for that, because it brings a lot of trust in us, and it also empowers us to come back every other Tuesday to talk about issues regarding land as we learn with other people from people that keep giving us this information. Council Alan, what are the key takeaways from today's discussion and your major emphasis? You always have those key points people should be looking out for in such a discussion. So what are those key takeaways from tonight?
Thank you, Fred, and all our dear listeners. Glad to hear from my good friend Munabi. Please welcome back from Pretoria. I missed you. I hope we catch up soon the coming days, physically and not online. But the key takeaways for our dear listeners, number one is distinguish between administrator and executor. An executor is solely named in a will. That is very key. An executor is only named in the will and will be bound by the terms and wishes of the deceased person as expressed in that will. An administrator, on the other hand, may or may not be bound by a will, but in most cases is never appointed by a will. A will only appoints an executor, and that is by the testator. An administrator is appointed by court. This is usually by family members gathering in a meeting and appointing one or up to 4 of their colleagues to be administrators. The other instance is where a widow, even when there's no family meeting, goes to court and applies and will be granted letters of administration, whether or without a will annexed. Now, the most important takeaway from tonight's discussion is, given all the roles and obligations of the administrators and executors, it is important that we note that whatever they do, they are holding this property of the estate of the deceased in trust for the beneficiaries. So whatever they do should be and ought to be for the benefit of the beneficiaries. Short of that, their mandate is going to be challenged in court. Something else that you can also note, it is introduced by the new amendment of the Succession Act as we go away, is that where 2 or more administrators have disputes and the 2 administrators do not agree, there is a new remedy that has been created by the Succession Act. You do not have to run to court and immediately file a case, but you can request for an arbitration. This is like a mediation, a meeting to have issues amicably resolved before you argue the legalese in a suit for revocation of letters of administration or letters of probate. With those few remarks, I want to take this opportunity to thank you, our dear listeners, especially the loyal listeners. I want to thank Amity Realtors and you, Gaman, for always creating this spot for us to be able to share this knowledge, because it is readily available, but we all know that legal services in the country are expensive given the high and stiff economic times we operate in. I want to also thank my colleague Nelson Mugenyi, who always helps me in preparation for these talks, and we do research together. He's on the call. A shout out to you, my brother. Okay, with those few remarks, allow me leave you for the night, Sugarman, and all our dear listeners. You can keep the comments coming. We shall always respond to them. Good night and bye-bye.
Thank you, Council. Thank you, ladies and gentlemen. Kindly do follow each other. Let's have these conversations going on. And most importantly, please don't keep silent when you are struggling with land issues. Do reach out to Amity. Do reach out to Council Alan. Do reach out to Godly. There's so many people that have come onto this platform and have been part of this community. So I want to thank you so much for listening in. Thank you, Amity, for always buying my coffee and my airtime to make sure that I never drop the ball, to be on time and be here to serve people to learn something about land issues. To Council Phil, please welcome back. We are so glad to have you back. I'll see you guys again next Tuesday. This has been a very wonderful episode. I have never got so many comments, both on my WhatsApp and in my Twitter DM, just like today has been. There could be something special about this topic. Maybe I just need to deep dive more into what people have been commenting, and then never know what topic we're going to have next Tuesday to make sure that this conversation gets grounded. So cheers. You guys get better, not bitter. We'll see you again next Tuesday, 8 p.m. same time. Good night.